Hi, you're watching Meet the Professors. We're here at the UC Irvine School of Law today with the founding dean, Erwin Chemerinsky, and we're going to talk about his book, The Case Against the Supreme Court. Thank you so much for joining me.
Thank you. It's a pleasure to be with you.
And for letting us use your fabulous law school.
Thank you. You're welcome to be here anytime.
Thank you. My first question was, what prompted you to write the book?
As I talk about in the introduction, I was teaching a case called Buck versus Bell. And maybe I can disclose here that you were my student in constitutional law a few years ago.
And I remember, gosh, almost 30 years ago, I remember you discussing that case in class.
It involved a Virginia law that allowed for the involuntary sterilization of individuals. It was a woman who was put in a foster home when she was 17. Her foster father's nephew raped her. She became pregnant as a result of the rape. Her parents were embarrassed by the girl's pregnancy. They institutionalized her. She gave birth to a daughter. And then Virginia began proceedings to have the girl who had given birth involuntarily surgically sterilized. And ultimately the case went all the way to the Supreme Court. And the Supreme Court, in an 8-1 decision, said that it was permissible to have this girl surgically sterilized. In the words of Justice Oliver Wendell Holmes, 3 generations of imbeciles are enough.
I remember that quote.
Well, it is one of the most outrageous, one of the most offensive Supreme Court decisions in history. And I realized after teaching the case that I'd been making excuses for the Supreme Court. I was trying to get the students to see it in the context of a time and the eugenics movement that was going on. And as I thought about it more, I realized that often in my teaching and my writing, I'd been making excuses for the Supreme Court. And as I thought about it more candidly and more critically, I realized that often over the course of American history, the Supreme Court has made tragically wrong decisions, especially at the most important times. And I decided I want to write a book saying that.
Yeah, well, you definitely make a compelling case against the Supreme Court. But for those people who may not understand, how was the Supreme Court created and how are justices chosen?
The Constitution creates the Supreme Court. Article 3 of the Constitution says there will be a Supreme Court of the United States and such inferior courts as Congress might choose to create. The Constitution provides that justices on the Supreme Court are appointed by the President, and once confirmed by the Senate, they serve for life unless they're impeached and removed or they resign.
Right, but there's 9 Supreme Court justices, and I remember...
Well, there's supposed to be 9. As we're taping this, there's just 8.
At the moment we have 8, but we've had 9 pretty much from the beginning.
No, actually not.
Oh, okay.
When the Constitution was written, there were 5 justices on the Supreme Court.
Okay.
And as the country grew, each time there was a new territory, an additional seat was created on the Supreme Court, until it actually in the 1860s became 10 justices on the Supreme Court. Andrew Johnson, of course, was the president who succeeded Abraham Lincoln. He was a terribly unpopular president. He was a Southerner from Tennessee who was presiding over the North's victory in the Civil War. And Congress didn't want to let Andrew Johnson replace a vacancy on the court, so they reduced the number from 10 to 9.
To 9, okay.
And ever since, and it's now been 150 years almost, it's been 9 justices on the Supreme Court.
Okay, and there was a time when it almost became more, when Roosevelt was having all his legislation struck down by the court, and there was this switch in time that saved 9. And what,
you remember
what was
your
that
constitutional
about?
law well. Exactly as you say, in the early 1930s, a very conservative Supreme Court was striking down the Roosevelt New Deal legislation. And so after winning a landslide re-election in 1936, Franklin Roosevelt proposed that for every justice over the age of 70, an additional seat would be created on the court up to a maximum of 15. This would have given Roosevelt 6 immediate appointments to the Supreme Court.
And all of a sudden, the legislation would be passed because it was 5-4, 5-4, 5-4, and then one switched to favor Roosevelt's legislation.
What's interesting is that even though Roosevelt was enormously popular at the time, his court-packing plan was controversial and very unpopular. It was seen as undermining judicial independence, but it was all made unnecessary when Justice Owen Roberts changed his mind and began to vote to uphold the legislation, where previously been the majority to strike it down.
Right. Now, are there any mechanisms? I know that the Supreme Court justices, like any justice in the federal system, have life tenure, but is there any way to get them out? Like there's impeachment, isn't there? It's possible. And has it ever been done? Could it be done?
The Supreme Court justice, like the president, the vice president, all office in the United States, can be impeached and removed from office for treason, bribery, or high crimes and misdemeanors. Never in American history has a Supreme Court justice been removed through the impeachment process. There's about 15 instances where lower federal court judges have been impeached and removed from office, virtually always for taking bribes.
Right. And you say, you have on page 53, you write, the court overall has done much more harm than good with regard to race. And explain that just briefly.
From the founding of the Constitution in 1787 until 1865, after the Civil War, not one Supreme Court decision ruled in favor of the rights of slaves. For that period, and we're talking here 78 years, every Supreme Court decision came down on the side of slave owners and very much protected the institution of slavery. The most prominent example of that was when the Supreme Court in Dred Scott versus Sanford struck down the Missouri Compromise, said that slaves are a piece of property. They're not persons, not human beings. From 1896 to 1954, of course a period of 58 years, the Supreme Court articulated and enforced the doctrine of separate but equal that authorized the segregation that existed in every aspect of Southern life. And it's not just that was then and this is different. Just 3 years ago, in June of 2013, the Supreme Court declared unconstitutional a key provision of the Voting Rights Act of 1965. And it's the first time since the 19th century that the Supreme Court has declared unconstitutional a federal civil rights law dealing with race.
Right. We're in the middle of a pretty serious terror situation in our country right now. We've had numerous killings by ISIS, not just in our country but around the world. So my question is there any black letter law on what the U.S. government can or cannot do in times of national crisis?
Our Constitution has no escape or suspension clause. Some constitutions around the world have provisions that in times of crisis the Constitution can be suspended. Some constitutions even create authority for martial law, but not the United States Constitution. On the other hand, over the course of American history in times of crisis, the Supreme Court has often ruled in favor of government actions that are terribly repressive. What's interesting from this history, and I describe it of course in the book, is that in hindsight we realize we weren't made any safer, even though there was a great deal of loss of rights. So you say, is there black letter law, clearly established principles? Sure, there's some clearly established principles. Congress can't suspend the writ of habeas corpus, except in case of rebellion or invasion. What does that mean? Well, habeas corpus is the way in which a person who claims to be unconstitutionally detained by the government can go to court. And the Constitution says that any person who claims to be unconstitutionally held has the right to go to court. And Congress can take that away only if there's a rebellion or an invasion. And so the Supreme Court in 2008 said Congress acted unconstitutionally in keeping Guantanamo detainees from being able to go to court because it was an unconstitutional suspension of the writ of habeas corpus. The law is clear now that the government can punish speech, even speech that's in favor of ISIS, only if it can show that there was a substantial likelihood of imminent illegal action, and only if the speech was directed at causing imminent illegal action.
The Brandenburg test?
That's exactly right.
Okay. Let's talk just a little bit about the liberal justices and the conservative justices, because I know we've had a lot of 5-4 splits over the last, probably since Kennedy joined the court. And tell us, what is a liberal justice and what is a conservative justice?
To start with, there have been 5-4 splits on the court as long as there have been 9 justices. 5-4 splits are nothing new. They didn't begin when Anthony Kennedy was confirmed in 1988. The only thing that's different at this particular moment is there can't be a 5-4 split because there's only 8 justices.
At the moment, right?
But there can be 4-4 splits, and there were last term. I think liberal and conservative are understood in the context of popular culture. A liberal justice is going to favor abortion rights. A conservative justice is going to be against there being abortion rights. A liberal justice is going to favor allowing colleges and universities to engage in affirmative action. Conservative justice believe that affirmative action is unconstitutional. Liberal justices want to allow the government to be able to regulate campaign spending, such as spending by corporations and elections. Conservative justices believe it's unconstitutional. Liberal justices believe that gun control is constitutional. They think that the Second Amendment is just about a right to have guns for militia service.
Right.
Conservative justices believe in gun rights, and there's a right of individuals
Right.
to have guns in their home for the sake of security. Liberal justices believe there should be a wall that separates church and state. Conservative justices believe we should allow much more religious involvement in government and government support for religion. I think you can understand the views of liberal and conservative justices by reading the Democratic and Republican platforms.
Now, going back to times of crisis and the Japanese internment camps during World War II, the Supreme Court ruled against the Americans who'd been here for, decades, who were then just rounded up and stuck in camps because they were Japanese. The court, everyone pretty much today says the court ruled incorrectly. They should have given a remedy. But who's in the best position in these times of crisis to make these decisions? For example, going back to ISIS, should it be our generals? Should it be our Congress? Should it be our president? Who is in the best position? Because ultimately it comes before the Supreme Court. And we're in a minute to talk about the reforms that you've proffered in your book. But who is in the best position to make these decisions, considering Americans have been murdered and they may continue to be murdered?
Let me separate what you say into two parts. First, let me talk briefly about the Japanese internment. It very much fits what I was saying to you a moment ago, how in times of crisis our government is engaged in serious repression and discrimination in a way that didn't make us any safer. During World War II, 110,000 Japanese Americans, aliens and citizens, and 70,000 were United States citizens, were uprooted from their lifelong homes and placed in what President Franklin Roosevelt called concentration camps. Not one Japanese American was ever indicted or convicted of espionage or crime against national security. There's no evidence that it did anything to make the country safer.
Right.
If there's any principle that should be clear, is that somebody's danger to society can't be presumed on account of race.
Right.
And yet the Supreme Court 6-3, in a case called Korematsu versus the United States, upheld the Japanese internment. The second part of what you ask is, who's in the best position to decide? I think the question is, decide what? When it comes to military strategy, I leave that to the president and the generals. In terms of the question of whether we should be at war, the Constitution says it's for Congress to declare war. But when it comes to the specific question of whether the president or Congress has violated the Constitution, that's the question that ultimately the Supreme Court is in the best position to answer.
Right, the final arbiter. Well, with regard to ISIS, based on what we do have, I know the Blackletter Law is sort of just a few cases, but what could our government do? In other words, could we stop all Muslims at the border and say, we have a threat from ISIS, it's a radical, Muslim group, what can we and can't we do, or do we know what the Supreme Court would do?
My view of the law here is that the government could keep anybody who has ties with ISIS from coming into the country. The government could not keep anyone who's Muslim from coming into the country. What's the difference? Well, people can be affiliated with ISIS regardless of their religion.
Of course. Yeah.
And it's also saying they're affiliated with a group that's known to be a threat to the United States. To say that all Muslims are kept from coming in is tremendously over-inclusive. A very small number of Muslims are affiliated with ISIS. It's also under-inclusive because there can be people who are not Muslim who are affiliated with ISIS.
Right.
And as I said a moment ago, the government should never be able to presume that somebody is dangerous just on account of his or her race or religion. Right. So I think a court would say that it's unconstitutional to keep all Muslims from coming in. Now, the only doubt here is there's never been a case exactly like this.
Right.
And also, courts traditionally given a great deal of deference to the government in terms of regulating the borders. But I think for the government to say no Muslims can come in would be unconstitutional.
Right. And right now we've got, a 4-4. We have 8 justices right now in the court. How critical is the next appointment, do you think?
The next appointment of the Supreme Court is so critical. And let me not just talk about the next appointment. Since 1960, 78 years old is the average age which a justice has left the bench. Justice Scalia was 79 when he died in February of 2016. In 2017, the year the next president is inaugurated, there will be 3 justices 79 or older. Wow. Ginsburg is now 83, Kennedy is 80, and Breyer is about to turn 78. So the next president, especially if he or she serves for 2 terms, is likely to have 3 and maybe 4 seats to fill on the Supreme Court. But just in terms of Justice Scalia's seat, on so many issues, who fills that seat is going to determine the outcome.
Right.
Campaign finance, the court would be split 4-4 today.
Right.
Guns, the court split 4-4 today. And so it all turns on who replaces Antonin Scalia and also who fills these other vacancies likely to occur in the years ahead.
Okay, we all know Scalia is very conservative. The other three who are over, or going to be 78 or over, Ginsburg's liberal.
Correct.
And who else was it?
Stephen Breyer, who's a more moderate liberal.
Okay.
And Anthony Kennedy, who's a more moderate conservative, but clearly the swing vote on the current court.
Okay. And one thing I was struck by in your book that I had to do a double take, I could not believe what I was seeing, was the Supreme Court's ruling on prescription medications that are generic, which pretty much all of us have taken from time to time. And I teach torts and I teach prox liability, and I was shocked that that isn't in my torts book. Explain what the Supreme Court said about prescription medications.
Sure. In a couple of recent cases, one was called Pleva versus Mensing and was Mutual Pharmaceuticals versus Bartlett. The Supreme Court said that makers of generic drugs cannot be sued for design defects, cannot be sued for failure to warn. Over 90% of all the prescriptions in the United States are filled with generic drugs when there's a generic equivalent to the brand name drug. Many insurance companies will provide prescription drug coverage only for the generic drug. But if somebody's injured by the generic drug, they can't sue the maker of the generic drug. Not for failure to warn, not for a design defect. And that can be changed by Congress, by statute, if people realize this.
How did the court reach that conclusion? Is there a statute they were interpreting? Or
yes.
Okay.
There's a statute called the HatchWaxman Act that was meant to encourage the development and sale of generic drugs. And it said that a generic drug could be sold if it's the same chemically as the brand name drug and if it has the same warnings as the brand name drug. And so suit was brought against the generic drug company for failure to warn. Suit was brought against the generic drug company for design defect. And the Supreme Court said, so long as it's identical to the brand name drug, you can't sue the generic drug company, even though you could sue the brand name drug company for failure to warn or design defect.
Why? What's the reasoning? I mean, the people are at risk, at greater risk by generic drugs because they're more often filled, the prescriptions are more often filled by the generic drugs.
I totally agree with you. One of the cases that I described involved a woman who took the pain reliever Suldenac. She was given the generic form of the pain reliever, and then 2/3 of the skin on her body burned, blistered, and decayed. It was a rare, though known, side effect, and she sued the generic drug company for failure to warn. And the Supreme Court ruled 5-4, the conservatives the majority and the liberals dissenting, that couldn't sue. It was preempted by federal law.
I told my husband, we are never, ever, ever getting generic drugs again. I just think that's insane.
And often you have no choice. And
I
if
know.
you want your insurance company to pay for it, you have no choice.
Well, and they're so much less expensive. You know, the designer drug, or what do you call it, the label, may be $200. The generics, $40 or $30. What a terrible, terrible opinion, in my opinion. Bush v. Gore, a big case, a case that a lot of people had a real hard time with.
I think that Bush versus Gore will be regarded as one of the embarrassments for the Supreme Court. The Supreme Court had no need to get involved in the case. The Florida Supreme Court said, let's count all the ballots. Let's count all the uncounted votes, and then we'll see where we are. The Supreme Court could have at least waited for that to happen. And instead, on December 12th, 2000, 5-4, the Supreme Court ordered a halt of the counting of votes in Florida, and for the first time in history, determined who was going to be the president of the United States. And
again, it was a 5-4 split, with the conservatives saying that, it should be Bush in office.
Well, they didn't say, to be fair, they didn't say that it should be Bush in office. They said to count the uncounted votes in Florida without preset legal standards risked denying equal protection. And so they halted the counting of the uncounted votes, and the practical effect of that was that George W. Bush became president.
And they knew that. That's what I'm saying. I'm saying maybe they didn't say, oh, let's put Bush in office, but the reality is when they voted as they voted, they knew that that was going to happen, and they basically took the election and decided for themselves. I mean, you say, well, 9 people decided the election. No, actually it was really 1 when you think of it, 5-4. We're a country of about 320 some odd million people.
I mean, again, I'm very critical of Bush versus Gore, but in fairness, we'll never know. Because even if the court had said that all the votes should be counted in Florida, we don't know that Bush may have come out ahead anyway. We don't know if Gore would have come out. So practically, they decided, and that the court decided on December 12th, and on Wednesday morning, December 13th, Al Gore conceded. Had the Supreme Court come out otherwise, the votes would have counted, and we'll never know who would have won that.
Right. Another big case, Citizens United. Explain that briefly and what that means for the American people.
Congress overwhelmingly passed a law known as the McCain-Feingold Campaign Finance Reform Act. President George W. Bush signed it into law. And one of the things that it did was to say that corporations and unions could not spend money right from the corporate and union treasuries to get candidates elected or defeated. They couldn't spend the money for broadcast advertising 30 days before a primary or 60 days before a general election. In 2003, in a case called McConnell versus Federal Election Commission, the Supreme Court 5-4 upheld those provisions. Corporations and unions could still spend money. They just had to create a political action committee to do so. But in 2010, the Supreme Court overruled McConnell and declared these provisions unconstitutional. What occurred in these 7 years? Did the court find some musty history of the First Amendment but let it leave a mistake? No, the difference was that Sandra Day O'Connor had been in the majority, and she was replaced by Samuel Alito, and he joined that those were the dissenters to create a majority. Justice Kennedy wrote for the court, joined by Chief Justice Roberts, and Scalia, Scalia, Thomas, and Alito. And the Supreme Court said that corporations and unions have the right to spend unlimited amounts of money in election campaigns from their treasuries to get candidates elected or defeated. A couple of years ago, Ruth Bader Ginsburg, in a speech in San Diego, said this is one of the worst Supreme Court decisions in history.
I think
history will confirm her beliefs.
Oh, yeah. I mean, that was, I think, the universal view of law among law professors. And just so people understand, what does that mean for the American people? What does this really mean for the average person going out and casting a vote?
What it means is that corporations and unions can spend as much as they want to get a candidate elected or defeated. Will it matter in the presidential election? Probably not. Will it matter in a city council race where a corporation really wants to get some pro-development person elected? Or in a state legislative race, or maybe a congressional race? Sure, right. Because when there's much less name visibility and name recognition, the advertising can make all the difference in the outcome.
Right.
It certainly has meant a tremendous increase in the amount that's spent in elections. We'll never know how many candidates choose not to run because they're afraid of the corporate wealth that'll be arrayed against them.
Right, there's no way to predict. There was one case that I read that I was very upset by, Lee Goldstein's case, and I was just in shock. And I mean, I taught constitutional law. We don't get into some of these cases, you know, we do basic survey of constitutional law, but I was not aware that there would be no remedy in a case like that, and it was just heartbreaking. Explain who Lee Goldstein is.
Tommy Lee Goldstein spent almost 25 years in prison for a murder that he didn't commit. At the time of his prosecution, there was no physical evidence linking him to the murder. At the time of the prosecution, there were no eyewitnesses linking to the murder. At the time of his prosecution, there's no confession about the murder. The evidence against him was two people who said they'd shared a jail cell with Goldstein and heard him admit to the murder. One of them later recanted the testimony and said Goldstein never said it. The other was a longtime police informant, ironically with the name Edward Fink. And Fink said that
the heroin addict. Fink, the heroin addict. Okay, just so we know we're talking about here. One witness, a heroin addict, Fink.
He shared a cell with Goldstein in the Long Beach City jail and heard Goldstein admit to the crime. When Goldstein was prosecuted for murder, his lawyer asked the deputy district attorney, had Fink ever made a deal to get reduced charges or sentence in exchange for giving testimony? Did Fink have a deal here to get reduced charges or sentence for the testimony? And the deputy district attorney said, no, never. Well, it turns out Fink had a long history of making deals to get reduction of charges and sentences, and he even had a deal in this case for reduction of charges and sentences, and it wasn't disclosed.
And Mr. Goldstein is a Marine veteran.
That's correct.
This is a person who served our country. You would think that people would look at his record of service and say, let's make sure, before we put a Marine veteran away, that he actually did something.
Many years later, a federal district court grants Goldstein a writ of habeas corpus and overturns his conviction, saying there's no reliable evidence linking him to the murders. Goldstein sued the district attorney's office, saying that they failed in their constitutional duty to turn over this evidence. And the Constitution does require that prosecutors turn over evidence that will help defendants. But the Supreme Court said that Goldstein couldn't recover, that prosecutors can't be sued for such behavior.
24 years in prison.
That's right.
Well, on page 342 you write, let's admit that the emperor has no clothes, referring to the Supreme Court. Let's admit there's a problem here. And then you offer some really interesting suggestions for reform. So what are some of those suggestions you have for reforming the Supreme Court to make it more accountable and just to make it operate better?
I pose many. I obviously pose changing the nomination and confirmation process. I'd like to see us go to merit selection for Supreme Court justices. Any president could do this. They could create a bipartisan merit selection panel and say, I want you to send me 3 names. Any name has to be approved by 2/3 of you. And I will either pick from your list of names or choose someone else. I think we should reform the confirmation process. I testified against Samuel Alito in January of 2006. At a break in the hearing, then Senator Joe Biden came up to me and said, this is all an exercise in kabuki theater. Everyone here knows that Samuel Alito is going to be very conservative. The Republicans are pretending he has no views and ideology. The Democrats are all trying to ask questions to pin him down, but he's too smart for that. We need a more meaningful confirmation process.
Right.
I propose term limits for Supreme Court justices. I think this would take a constitutional amendment, which makes it unlikely, but I propose 16-year non-renewable terms. I propose changing the way the Supreme Court communicates with the American people. As an example, I think there should be cameras in every Supreme Court proceeding. What the Supreme Court does affects all of us. Often the most intimate, the most important aspects of our lives. We should be able to watch it. The ethical rules that apply to other judges in the country should apply to Supreme Court justices too.
Absolutely, the most powerful ones. And you can't even get a seat at a hearing before the Supreme Court, right? There's what, 150, 200 seats in there?
About 350
oh,
seats
it's
in the whole
350,
chamber.
okay, it seems smaller. And you get the hearing, you can hear what was said on audio tape online after the fact, but you're saying there should be a real-time coverage of what's going on in our highest court.
It's inexcusable that we can't watch the justices, they hear arguments, or as they hand down decisions from the bench.
Right. Well, thank you so much for being here. This has been awesome. Your book, this is really a great book. You could learn all there is to know about the Supreme Court's history and how they've ruled and why we should really reform this court. So thanks again. And this is Deana Pollard Sacks. You've been watching Meet the Professors, and we've been discussing Erwin Chemerinsky's book, The Case Against the Supreme Court. Make sure and subscribe to my YouTube channel at www.meettheprofessors.org. Thank you for watching.